develop the skills of judges, tools like plea bargaining, develop the skills of judges, implement the continuous trial, and I'm proud to say also that this continuous trial and plea bargaining cases and other tools, Your Honor, have considerably reduced the dockets of the court. And if I may be allowed, Your Honor, we are proposing, and I brought the idea to the NBank, that it's now time to amend BP 129 on the jurisdiction of the RTC. Because if you remember, Your Honor, insofar as a sum of money is concerned in the first level court, the jurisdictional amount is 300 pesos for those outside of Metro Manila and 400,000 pesos. These amounts were fixed in 1999. And the amount in the recovery of possession, the recovery of ownership, except...
The red light is on.
Okay,
I have one question.
Okay, Your Honor.
What makes you say you are better qualified now than you were the last time you applied for the Chief Justice position?
Now, for all these years, Your Honor, even when I was in the private company, I always practice this principle. I lead by example, Your Honor. And I believe that I have the qualities of a good leader. With the number of years that I've been with the Supreme Court and as a trial judge, I think I'm better now to be Chief Justice if given the chance.
Thank you, Justice Peralta.
Thank you, Your Honor.
Justice Mendoza.
Thank you very much, Judge De Monteverde. Justice Tiha.
Good morning, Chief. I address you as Chief because when we were together in the court, you were senior in the court. I have known you for many years, but professional ethics demand that I do not say anything to defend you or highlight your accomplishments. To those people who do not know you up close and personal, who might have a different impression of your personality, are you by nature an arrogant, difficult, unapproachable person? And if so, are these endearing qualities of a good Chief Justice?
Yeah, Your Honor, please, I think you were Justice Mendoza, and you were with me many times during the deliberations. Probably you will be the first to tell to everybody if I'm arrogant or not. Probably they misinterpret arrogance to passionate. I admit that I'm passionate in all the deliberations, and I'm passionate especially when judges are charged with serious offenses. And I always insist in all our deliberations that we have to impose the severest penalty if the judge has committed a serious offense. Insofar as being arrogant also probably outside the courtroom, Your Honor, it will be lifting myself, so to speak, if I say that probably I'm the most approachable justice in the Supreme Court. That's really what I am. That's really what I am, Your Honor.
I will not ask you about the Adam and Eve question about addressing the problem of docket congestion, because that has been asked repeatedly in all interviews before the JBC, and interesting and answers were given. But up to now, it seems that we cannot address really the matter of case congestion, not unless we limit the number of cases that go up to the Supreme Court, or we change the mindset of the public that they should accept decisions which are correct and fair without waiting for it to reach the Supreme Court. So are there measures being undertaken so that, like the U.S. Supreme Court, there might be some cases which need not be elevated to the Supreme Court on certiorari, and then the Supreme Court can decide which cases it should take cognizance of.
Yeah. There was a time when we were consulted by the former Chief Justice. I think you were not there. I was suggesting, Your Honor, that one justice from each of the three divisions, on a rotation basis, will be tasked to filter all these cases before they are assigned or before they are raffled. But the problem in that suggestion that I had is that, but the Supreme Court, but the cases in the Supreme Court should be decided by the en banc or by division. So that was the problem. So my suggestion was not taken. So we have to continue with what I've been doing. But two or three sessions ago, when Justice Sardelesa came out with that case in Samar, where we have now to dismiss cases if there is a violation of hierarchy of court, I suggested likewise that we should have to include dismissal of cases based on due course. Because with Rule 45, which is a discretionary appeal, I'm sorry if the answer is long, because for the understanding also of the public, Your Honor, we all know that if it is brought to the court on Rule 45, which is a discretionary appeal, we use what we call deny the petition on the ground that no reversible error. That's what we have been doing. Or file of time, that it is Rule 65, then we say, despite no God, dismiss with the grave abuse of discretion. We've been doing that. Now, the problem, Your Honor, is that I have, in fact, I brought this out. I said, with due respect to my colleagues, I said that if the petitions are original petitions before the court, and it is concurrent with the Court of Appeals, for example, writ of habeas data, writ of amparo, continuing mandamus, the writ of calicasan, all these petitions are concurrent with the Court of Appeals. If the justice, the member in charge studies it, and it is not in accordance with form and substance, then we deny that due course. That's one of my suggestions. Because in the meantime, these are only the solutions. They are the solutions that we can implement.
It's not the fault of the Supreme Court, because the bottleneck really is in the Supreme Court.
Yeah.
Because you take into consideration all cases coming from the lower courts.
Yeah.
Now, my other question is, are you aware of the judicial bureaucracy, the organization in the judiciary? You have something like almost 2,000 probably judges nationwide. The justice system will fail if judges misbehave, and even lawyers who are under the supervision of the Supreme Court, because lawyers are granted the privilege to practice law by the Supreme Court, and there are about more than 100,000 probably practicing lawyers already. The question is, how do you monitor that lawyers do not misbehave? How do you monitor that judges do not misbehave? Considering that you only have the office of the court administrator, which office may be undermanned. Now, I understand, I am fully aware that we assume that lawyers do not misbehave or judges do not misbehave if there is no complaint.
That's correct.
That's the only time we come into the picture. So, for example, the IPP, I don't think effectively police their own ranks. They investigate lawyers if a complaint is filed against lawyers. In the same token, the Supreme Court does not monitor the performance of judges unless somebody complains. And the only time the court administrator monitors is with so far as work output is concerned, fiscal accountability, and things like that. So how can you effectively initiate reforms if you do not monitor their performance?
Well, first one, Your Honor, we have really problems of lack of personnel in the office of the court administrator. We have only 11 judicial supervisors conducting audits, probably around 2,500 courts now, because we have created family courts and also other courts, all with only 9 judicial officers. And that's correct. The Supreme Court will only act if a complaint is filed. But when I was interviewed the last time, Your Honor, I suggested